And now there will be a contribution by Dr. Martin Kornel on a topic of the protection of minors born out of wedlock. So please, you can start.
Thank you, Tiff. Good morning, ladies and gentlemen. I hope that you can hear me and you can see me. I don't have a presentation for you, so I hope that my face would be enough to keep your attention on my speech, hopefully. The problem of the position of a child born out of wedlock might be a problematic one, definitely. Historically, the position of a child born out of wedlock was definitely problematic through the history. We have seen many traumas, starting from the high risk of infanticide and being killed by even his or her own parents. And of course, also the law approached to such a child differently compared to the children born into a marriage. Among such differences, we can count, for example, different position of a child, speaking about the parental rights. So the position of a child born into a marriage and out of wedlock was different, speaking about the duties and obligations of the parents and also of the rights of such a child. Good example and a proof of the difference might be also a terminological one, because such a child was for a long time called illegitimate child, meaning something like an unlawful offspring, meaning conceiving and giving a birth to such a child might even be sort of unlawful or problematic per se. Aside, speaking about the other problems that might such a child face from the perspective of the law, it might be succession law. So speaking about inheritance rights, such a child could have no or very limited rights, speaking about inheritance from a father or even from a mother. Father might be or has been by the law relieved from paying child support for some period of time, and also the possibility of such a child to acquire a citizenship has been limited through the history. Nowadays, many of those differences are not yet in the law. But in some jurisdictions, like an Islamic law, for example, we still can see that the law handles differently the children born into a marriage and out of wedlock. And even countries like Japan has changed their approach very recently. For example, in Japan Supreme Court in 2013, they took a decision that recognized the discrimination based on the status of the child born into a marriage and out of wedlock in some areas of law, and it brought some changes to the Japanese practice. Speaking about current Czech context, I would like to bring your attention to three specific issues. The first one is the necessity to have a custody procedure in front of a court. I will talk about it in a more detail in a brief time. Second one is the affiliation, so finding out who the father of a child is. And the third difference I would like to bring your attention to is acquiring of the Czech citizenship. So let's start with the custody procedures. Speaking about Czech law, before the divorce of the parents, the court procedure must, there has to be a court judgment on a custody and maintenance of the child. is obligatory. You cannot be divorced without such a judgment. On the other hand, if the parents are not married, there is no obligation to go to the court to have such a judgment. You don't need to have your parental agreement recognized by state authorities and nothing of that kind. So that is obvious difference in treatment. And the question is, which approach is actually better? There are obviously some, well, we may say that if there is a necessity to have a judgment before the divorce on custody, then of course the state has a better possibility to control whether such a child is not in a danger and to have a clear picture about the situation and the position of the child. On the other hand, necessity to go through the court proceedings might lead to prolongation of the procedure, to escalation of the conflict of the parents, and that is obviously a weakness of such an approach. Therefore, the authors, some authors, for example, Romana Rogalevichova, calls for same approach to both parents, meaning, both parents and both children, of course. Meaning the children born out of wedlock and into a marriage. And of course, there are two possibilities. One, to not ask, to not demand a court decision on a child custody before the divorce, or to make obligatory judgment also in case of the children born out of the wedlock. Well, the second approach is impossible from my perspective, because you cannot, well, it would mean that the court would need to handle much more cases than nowadays. That is the first problem. And the second one, the state obviously doesn't have a control over the parents who are not married, so the state doesn't know whether they are living together or not. Therefore, from my perspective, only really possible way how to handle that would be the amendment of the legislation demanding the obligatory judgment on the custody of the child before the divorce. Obviously, it might be questionable whether to do so, but if we really would like to approach to those children in the same way, there is only way how to handle that from my perspective. The second issue I would like to bring your attention to is the affiliation. First of all, we need to clarify and to make understandable that actually, if you are a father of a child, I mean biological father of a child who is born into a marriage, there is, according to Czech law, actually no way how to challenge fatherhood of a legal father and to establish a relationship, I mean legal relationship between biological father and child. That possibility might be problematic from the perspective of Article 7 of the Convention on Rights of the Child, as far as a child should have a right to know and be cared by his or her parents. But, well, the Czech Constitutional Court and Czech Supreme Court provided sort of a possibility how to establish some legal relationship between the biological father and such a child. Yes, that possibility is, at least from my perspective, again, very problematic, because it would be sort of a declaration of parenthood, but it would not establish any actual legal relationship, taking aside of the mere fact that you are a parent, but you don't have any parental rights, except a possibility to ask for a contact with the child. And obviously, the contact with the child is much less than parental responsibility, custody, and so on. Therefore, if we would like to approach to those children born into a marriage and out of wedlock in the same way, from my perspective, the only possibility would be to allow challenging fatherhood of a husband, of a mother, by some other person than just a wife and a husband. So it might be a child, or it might be a man who is claiming that he actually is a biological father of a child. Well, and the third area I'd like to cover today is the citizenship. It is actually a clear distinction between the child born into a marriage and outside of the marriage, out of wedlock, because Czech legislation clearly says that the child born out of wedlock will acquire Czech citizenship only if it's proven by DNA test that the father, I mean legal father, is actually also a biological father. No, and well, that legislation would actually apply if a mother is not a Czech citizenship and not a Czech citizen, a father is a Czech citizen, and they made an affirmative statement of a fatherhood of that man. On the other hand, if a mother is not a Czech citizen and a father is a Czech citizen and they are married, then no one asks for any DNA test to prove that the child that was born into a marriage is actually really biologically related to the father and meaning a husband of a mother. Well, and from my perspective, such approach, well, doesn't make any sense because I don't think that there is such a huge difference, and there is, well, obviously, the man and the woman may enter into a marriage also if they actually don't want to live together. It's actually the same as if they will just declare that he or she, that he is a father of a child, and therefore I would like to see that the approach of the legislation would be similar to both fatherhood that is actually acquired by affirmative statement or by marriage. Thankfully, such difference in treatment is not present in the legislation that regulate residency status. So the possibility to acquire a residency status is not bound to the necessity to prove that you are a biological father of a child. So I wanted to bring your attention to three specific situations when Czech law still handles position of a child born out of wedlock differently. I hope that it was interesting for you, and I look forward to your comments and thoughts at the end of the session. So thank you very much for your attention, and as I said, I look forward to your comments and thoughts later on. Bye.